I'd like to welcome everybody. Thank you all for coming. We are mostly lawyers in this room, but we do have a group of non-attorneys who are with us today for the support committee of the Fort Dix 5. So if we could take into consideration when we're talking, if we could just, explain a few things that maybe non-attorneys wouldn't understand. So we have an excellent second panel for you all today. We have our mediator today is Mr. Michael Deutsch. Mr. Deutsch has been an attorney for the People's Law Office in Chicago since 1970. And you have his bio, so you have the bio of all the speakers, so I'm not going to read it all out for you, but just to give a quick introduction, Mr. Deutsch actually worked on the Mohammed Saleh case, and he has worked on several other terrorism-related cases. Our first panelist today is Mr. Sam Braverman. Mr. Sam Braverman is also a criminal defense attorney who's been practicing for over 20 years. He represented Lagarde Payne in the Newburgh 4 case, and I actually just learned today that he represented Edgar Morales, in which you're attempting. Yes. And then our next panelist would be Miss Janice Basil. Miss Janice Basil. Okay. Well, she's been a trial attorney also in the areas of family law and criminal law, and her case was the Tariq Mahana case, which is a huge case that just happened recently in Boston, Massachusetts. And our third panelist is Mr. Zwirling, and Mr. Zwirling has been an attorney for a long time as well.
6 months.
And he represented Saifullah Chapman in the paintball cases, and he also represented Abu Ali, who was a Texan accused of trying to kill George Bush. So please welcome our panelists, and looking forward to an interesting panel.
I'm going to begin. I'm going to sit, but I'm going to speak loud. I've been representing political militants in federal and state court for over 40 years. In the 1980s, I represented people who were Puerto Rican independentistas who were accused of being members of the FAON. They were charged with seditious conspiracy for the first time that statute was used in 50 years. Conspiracy to oppose the legal authority of the U.S. over Puerto Rico. The government put cameras inside people's homes. There was no statutory authority for it. They had no court order. And the judge suppressed that evidence, and on appeal, the Seventh Circuit said that the government had inherent power to investigate terrorism and therefore could enter people's homes and secretly put cameras in. We had anonymous juries, extensive motions in limine where we couldn't raise the issue of Puerto Rico in any shape or form, and they were sentenced to draconian sentences of 55 to 90 years without any terrorism enhancement law. So you can see that the use of terrorism and the branding of people of terrorism has affected the law even before 9/11. After 9/11, I've been involved representing Palestinian activists from the Chicago area. Right now I'm representing Hatem Abadea, who is facing material support charges, who's been waiting for an indictment for 2 years. His home was raided. He was subpoenaed to a grand jury, refused to testify, and he is the executive director of the Arab American Action Network. Also, we are representing, along with Tom Durkin, who's not here but probably will be later, 3 Occupy people who are charged with state terrorism in Illinois. The first time the Illinois law of terrorism has been used at any time until it was passed after 2011. They're charged with material support for terrorism and conspiracy to carry out terrorism. I was one of the lawyers for Mohammed Salah and Abdolim Ashgar. We had a 3-month trial in Chicago. Mr. Salah, who was very beloved and active in the Palestinian community in the Chicago area, was arrested in Israel in 1993, bringing money to people who were involved in the Intifada. He was tortured for 55 days. He ultimately was put in a cell with people he was told were militants in the Palestinian movement. They were actually cooperating people who were working with the Israelis. He was tortured by them in a cell. He was forced to write a 55-page confession. And after that, he was secretly taped for 5 hours while being interrogated by the Shin Bet, the the Israeli secret police, and they got a full confession on tape. And I'm going to talk a little bit about challenging that confession in court and how you deal with the motion to suppress when you're dealing with foreign interrogators. But one of the things I want to do in this short time that I have is kind of give an overview of how to look at a terrorism case. I think one of the most important things to do in a terrorism case is try to figure out how to humanize your client, to try and figure out what ways you can build some understanding among the jury or even the judge about what your client is about, what his background is, what would cause him to be in any way involved looking in the internet or going to a meeting or making a speech, and to try and develop some identification, some goodwill, and ultimately some sympathy. Otherwise, you're in a very difficult situation, and in order to get some kind of activity and some kind of support from a jury, you're going to have to make your client seem other than a scary terrorist. And there's various ways to do this, and obviously you can't do this all in every case. There's different facts, and you have to deal with the facts that you have. But I think it's important, even though there are dangers involved, to try and project a political and social context in which the case arises, to try and develop an understanding of why your client would be associated in any way, even in a innocent way, with the issues that give rise to the indictment. Now, in the Palestinian situation, it's much more easy to do that because you're talking about an occupation, you're talking about people who have been driven off their land, you're talking about a lot of political issues that you can educate a jury about and even a judge about over a period of time. So in those kind of cases, when you see there's some kind of political context or social context, even though you're saying, oh, wow, the jury's not going to like this, they're going to think, you know, somehow that this is, you're supporting terrorism or you're supporting Hamas or whatever, you're going to have to take that leap. You're going to have to somehow defend your client in a way that explains to the jury what the Palestinian struggle is about. Now, obviously, in other cases, you might not be able to do that. With other clients, with other situations, it may be more difficult. But another way to humanize your client is to get support from your community. And it's very important for the jury and even the judge to see people coming to court to support your client. They look at you and they look at your client, and if you're there by yourself, there's nobody from the community there in court, they say, well, this person is just, you know, an outlier. But if your client and your community comes to court and it fills that courtroom, the jury's going to notice that. In the Mohammed Salah case, people would line up at 7 o'clock in the morning to get into court. And hundreds of people came to that courtroom and filled that courtroom every day. In fact, they had to open up a second courtroom which piped in the video of the case because so many people came. Another way to try to develop understanding is to question the motivation and tactics of the government. If the jury and even the judge seems to think that the government is playing fast and loose, that they're doing things that are illegal or they're violating your client's rights, that's going to create some kind of sympathy with your client. Also, you should talk about if you have the facts on your side, your client's family background, your defendant's family background, you should be injecting those things from the very beginning of your case so that you're creating a feeling, an atmosphere in that courtroom that is not just the government doesn't just control it, that you have something to say and something to say that's important. And I think you should try and put these issues, if they apply, right in your jury questionnaire, raising issues of First Amendment in it. How does the jury feel about the First Amendment? How does the jury feel, or what do they know about the Palestinians? Raising those issues right in your jury questionnaire is going to ferret out some people right away who are prejudiced against your client or the First Amendment or the rights of defendants. And also, it's going to educate other people who read that questionnaire and starts to answer it. Also, when you do a questionnaire, and I guess it all obviously depends on the judge and the situation, but you should not make it so extensive that you don't have the right to follow it up with your own voir dire. So you should leave some room for the ability to ask questions and the ability to follow up on things that a juror may say that you can use, number one, to get rid of a juror, or number two, to educate that juror about some of the issues in the case. One of the questions that was very successful in our case to get rid of jurors that were unsympathetic, it worked for a while and then the judge just cut us off, but we got rid of about 10 jurors. We would say to the juror, now the government says this is a terrorism case. Now in a terrorism case, would you start out favoring the government? And the juror would say, oh yes, for sure, yes. And then we'd say, well, we challenge that juror, and the judge would have to knock that juror off. And we did that about 7, 8 times in a row, and then the judge said, I'm not letting you ask that question anymore. But we were able to get rid of those jurors, and this was very successful for us. Your opening statement, you want to tell the story of your client if you have those facts. Even if your client's not going to testify, it doesn't matter, because it's too late once the jury's heard this. If your client doesn't testify, well, that's too bad. In our case, in the Salah and Ashgar case, we put out big maps of Palestine, and we showed how the Palestinians' land was taken from 1948 to 1967 and to the present time. We talked about Muhammad Salah's history, how he came to this country, how his family was driven off their land, how they lived as refugees in refugee camps, how they were forced to go to Jordan. All these things are talking about your client and humanizing him and telling the jury, this is a real person. This is not just somebody the government says is a terrorist. This is a person with a family, with a history, and this is a way to get the jury to begin to sympathize with your case. And obviously, all through the trial, you're looking for ways to raise those political, social issues, to inject some humanity into your client, to talk to your, have your client, talk to him during the case and show that you're with him, basically. You're sitting with him and supporting him. Now, I want to talk a little bit about the suppression issue in the case, because it was quite unique. For the first time, the government came to us and said, oh, we're going to do you a favor. We're going to bring the interrogators to the U.S. This is the first time Israeli interrogators have ever come to the U.S. And we're going to let them testify in court. Oh, we said, oh, that's good, great, So what happens is they bring them to court. They close the courtroom. They allow only the defense lawyers in the courtroom. They put black sheets over the door to the courtroom, and they bring in 7 or 8 Israeli lawyers and security people. So the courtroom is filled with Israeli lawyers and security people. And these interrogators, they brought 2 out of 15 interrogators. And basically they say these people are going to testify, but they're going to testify in code names. They're going to wear light disguises. And you're not going to be able to question them about everything. And we had been fighting with them about the procedures and protocols of the Israeli interrogation methods. And as you may know, if the government, a foreign government, provides information, documents to the U.S. and says they're confidential or classified, they're automatically classified by the U.S. government. And there's no way you can get around that. And in fact, there were hundreds of documents that were classified and that we couldn't see. All the methods, all the procedures, all the uses of interrogation by the Israeli interrogators. And then when the suppression hearing started, every time we would try to go into methodology and ways, what they were allowed to do, the Israeli security or lawyer would whisper to the U.S. attorney, and the U.S. attorney would stand up and say, that's classified. 250 times that happened. And then ultimately, we got some very weak stipulations or substitutions under CEPA. You can get some substitutions, and the judge would meet with the government and the Israelis in secret throughout the hearing. They'd have all these ex parte conferences. We weren't allowed in. Our client wasn't allowed in. And they wouldn't even let the judge see some of the documents. It didn't matter whether we had clearance, we weren't allowed to see them. The judge said, I'm not even allowed to see some of these documents. Ultimately, we lost the suppression hearing, even though we brought in experts, Israeli human rights experts, Palestinian human rights experts, experts on torture, and there are very strong evidence of coercion and torture. The judge said, no, I think all this was voluntary. But the problem was for them was we're going to have a jury now. And how are they going to deal with the jury with all this classified information? So we had this huge fight with the judge and said we're not getting a fair trial, it's all secret. To make a long story short, because they're holding up 1 minute and they don't have much time, we were able to get some very good substitutions for the jury. Basically saying that they're allowed to keep people without sleep for 72 hours. They're allowed to tie people to small chairs. They're allowed to beat people around the head if they're not cooperating. They used the birds. These were these Palestinians that were, and the birds are not monitored at all. And what happens in the birds, they don't know. And what would happen is that you'd be cross-examining one of these interrogators, and in the middle of your cross-examination, you could turn to the jury and say the government has stipulated that they can keep people up for 72 hours. And then you go back to the cross-examination. And then you turn again and you read another stipulation. And you keep doing this over and over again. So by the end, the jury knew, even though all this classified information you couldn't get hands on, the jury knew that this was a coerced confession. And ultimately, Mr. Salah and Mr. Ashgar were acquitted of the RICO charge. They were convicted of 2 minor charges. I mentioned not minor in the terms of sentencing. Mr. Salah was convicted of not being honest in a civil interrogatory in a civil case brought by the Israeli lobby. And he got 21 months for that. He's out. As you may know, he had been on the terrorist list, the only U.S. citizen on that terrorist list for 17 years. Even after he was acquitted of the RICO, and even after he came out of prison, he was still on that list. And we brought a civil suit in the federal court in Chicago, and the day before the government was supposed to answer, they agreed to take him off the list. So Mr. Salah now has a bank account. He's now allowed to buy his wife flowers and candy and take his kids to the movies. And so that's a good outcome of the case. I'll stop there.
Yeah,
great.
I'm up. All right, so one of the things I want to talk to you about is discovery. And I call this discovery in monster cases. There is one of the things that we've all heard about today is how the government defines discovery. And when they discuss, and I was having a good conversation earlier with Tariq, how the government defines terrorism, and how the government defines criminal, and how the government defines materiality. The government is in the business of defining things for us. And when the government defines everything for us, we are then in this battle against their definitions. And I think the point raised there was a really good point. In terms of discovery, that's why you have to find other ways to do discovery. The government has essentially 3 obligations. They have obligations under Rule 16. They have obligations under Jenks, or 3500, or 26.2. And they have obligations under Brady. And they define what these things are. Rule 16 and Rule 3500 are, Rule 16 is in the Federal Rules of Criminal Procedure, and Rule 3500 is in the United States Code. They essentially require the government to turn over exhibits, things that they're going to introduce on the direct case that are in the government's control. And then some of them have a very substantial material to the defense requirement. You have to show why it's material for the government to do it. It excludes all their work product. And under Jenks, it excludes, you don't get it, except under statute, until after the witness has testified. So you can imagine that you're going to have a sporting contest of some sort, and they said, okay, so we're going to tell you how the first half went after the first half. It'd be a little hard to prepare for such a contest. Right? If you were on a test, they said, well, tell you what the questions are sometime in the middle of the test. That's kind of what this discovery thing is. So your job in all these kind of cases is to find out what you can find out. One of my own rules is that if X is true, some 10 different Y's must also be true. They just have to be true. Forensically, if I fire a gun at this door, then there's got to be a hole in the door. If it's true that I fired a gun at the door, there's a hole in the door. If there's no hole in the door, some other part of the story is false. And so you always want to just keep thinking about, how do I know? If forensically that proves a point, discovery that must prove a point. If you're talking about the government says, this happened, well, we know that from the conversation earlier about they're spending millions of dollars on things. If it happened, somebody's paying attention to it. Somebody's paying attention to it, there's a document. There's a document, there's an email. If there's an email, there's a conversation. There's a phone record of a conversation. There's another thing out there that exists because of this original one point. And if it's 10 things that exist, you are getting this kind of geometric advantage against the government. Now you're trying to force them to go look for things. And in the trial that we had, we got just blind stinking lucky because we're supposed to start jury selection or the trial on June 14th of a particular year. And on June 11th, they give us another 200 pages of discovery, in which is the thing that says, essentially it's an FBI report that says the lead defendant, it's a letter to the Stewart Air Force Base where the lead defendant was supposed to be ready to blow up planes. And it says, if you see the guy, don't worry about him because he's non-operational without our assistance. It's a remarkable thing. It was, it was document 178 or something in this thing. It didn't come with the post-it that said, holy cow, here's what you've been looking for a year and a half. It didn't come with a flare or a roadmap or anything that said, by the way, this is what you've been looking for a year and a half. It comes buried. So that's the needle in the haystack idea. And these things exist because sometimes agents are careless. They write down a conversation that they should know we're going to see eventually, and they should probably not write it down. They should bury it with all the other Brady in the Brady safe someplace in the Department of Justice. They should find ways to not let us see it, because if we see these things, we're going to ask questions. So your job in discovery is to ask. Keep asking again and again and again. You see all these great stories about somebody files a FOIL request to 2 different agencies and gets the same document but redacted the opposite way. Because somebody takes an approach and they don't think about it, and you, by continuing to ask, you get these things. So that's what I want to encourage you on. I want to encourage you to keep asking. So Rule 16, 3500, and Brady. Brady, Giglio, things like that. The government is allowed to define these things for us. That's one of the worst problems. They define Brady, define it as materiality. If it's material, then they make a Rule 404B motion as to why you can't do it. If it's not material, you don't get it. So it's back to the constant definition of things. So you need to go out and find these things. So things that I'd like you to do. I'd like you to start, my favorite thing is just start Googling everything. There's no part of a case that's not subject to your Googling it. Just start Googling everything. Every word in the indictment, every name in the indictment, every city in the indictment. My wife was here as another lawyer, and she got me onto this idea. There's a thing called crowdfunding, where you can micro-lend to things. You get 50 people to donate $1, you have $50. Crowdsourcing is a new way of starting to think about things, and Google is essentially crowdsourcing for investigative theories. You have to sift through a lot of stuff. But if you start Googling every part of the case, you're amazed at what gets written down out there, what's out there in the universe. And all those things are available to you. So you need to crowdsource your problems. When I got my terrorism case, I was brought in because the previous counsel, who was a good lawyer, just couldn't communicate with my client. Problem is my client's insane, so it's a little hard to have a conversation with my client. There are times when he spent most of his time in segregation throughout the trial. He would be sitting, during the trial one day he comes in, and when the marshals walk into the courtroom, they come back out, he's naked and smeared with feces in his cell. So we spend a day or two working on those sort of things. So it's hard to work with some of your clients, but it doesn't matter. You're still out there, you're still trying to do these sort of things. I want you to crowdsource your thoughts. Because when I got this case, I felt alone. I thought, here was 6 boxes of material, be ready for trial. Even my co-counsel, they were a year ahead of me. They're like, you're the new kid, tell us when you're ready to come up. And I felt really alone in this. But the fact is, for all of us in this room, and there's 500 more lawyers around the country who are doing what we're doing. And if you're talking to these other people, they have ideas. You're not constantly reinventing the wheel. Google's a great one for those sort of things. Subpoenas are a great thing. I love the fact I can walk into a federal district courthouse and I say, subpoenas, please. How many would you like? Oh, I don't know. Give me 30. Okay. So they take out a big stamp machine, they stamp up 30 subpoenas, and they say, here you go. Use them. I mean, they're great. They're like credit cards for justice. You get to go out there, I'd like to charge up one of these things, and you send a letter off to somebody, and you send a subpoena out there. The government will then figure out that you've sent out these subpoenas, come in and move to quash, but you learn something in a motion to quash. You learn that they've got to come in and defend a point, and maybe they're careless with a word. If they're careless with a word, you've learned something. You say, oh, another place to subpoena. Something else to do. And then they say, oh, damn that Braver, I want to stop saying things. Then maybe you win an argument because they don't make the argument properly. There's this thing that they should be, that you should be polite, but you should be persistent, and they should think of you as a walking minefield. Every time they say something or do something, you think there's something I can follow up with that. And that's the approach I want you to take for all these things. You need to write to the judge. You need to write to the DA's office. You write to the local police departments. You need to write to all these people and say, I want what you have. Somebody was saying to me earlier today, I think actually, you were telling me that you wanted to file something and the judge is like, I'm not going to accept this motion, or something like that. The great thing about ECF is it's out of their control. You know, you just ECF things, and the judge says, well, I'm going to deny it. I knew somebody once, I thought this was particularly clever, made a motion for discovery and some procedural things, and titled it Motion for a Fair Trial. And then the judge ultimately denied the motion. So I was like, I thought that was just, it was clever. It had a nice thought to it. It was probably right, absolutely. But so you want to do that. You just keep filing things with ECF. I tried a case in front of a judge who, every time you want to make an argument, he would say, the jury's coming at 9. He would take the bench at 8:58 and say, Mr. Braverman, anything you want to raise on the record? And when the jury walked in at 9, he would say, okay, the motion's denied. So you had to just speak like the guy on the car ads. Judge, I think I want to make a motion at this point because I want to do this. You know, it's just absurd stuff. So ECF is fabulous for that. The converse side of ECF is that everybody else out there is doing this. So you ECF every case you see in the newspaper. If you see in the newspaper, we were doing jury selection in our case, and we were thinking about it. Judge said maybe we'll do a questionnaire. Well, during that time, Barry Bonds had a questionnaire in his case. John Edwards had a questionnaire in his case. It's the great thing about it. I figured if John Edwards is on trial, he's paying $10 million for his defense. Barry Bonds, what does $10 million buy for a jury questionnaire? ECF, there it is. There's the questionnaire. And I said, oh, that's an interesting question. So I'll take that question, I'll take that question, I'll take that question. They're all out there. They're all available to you. So every time I write something, every time Michael writes something and it goes up on ECF, that's, as far as you're concerned, that's legitimate sources for you to be looking at. You need to be doing that. Another one that I happen to like is the Cornell Law School has a listserv. And I actually, it's one of the only sites that I brought here. It is law.cornell.edu, and it's called the Legal Information Institute. You can get on an email list, and I think I just love this. They have an email list of every case that's been granted cert that week by the Supreme Court. You can then download the briefs. And so one of the times I argued a case, and I wanted to make a point, and I argued to a judge, and the judge was like, that's stupid, you don't know what you're talking about. Thank you, Judge. I really appreciate that. My client thinks more of me now for your saying that. Anyway, so while I was pending my case to the Court of Appeals, the United States Supreme Court granted a case. Cert in a case was called Kimbrough. And Kimbrough was the idea that you get to present enormous amounts of background information about your guy to really give life to 3553. 3553 is it's the nature and circumstances of the case and the defendant. So I saw that, I took the brief, I dumped the points into my Second Circuit brief. Because if the Supreme Court, 4 people in the Supreme Court thought it was interesting, maybe it was. This remains now 21 years into it, the only case I ever won in the Supreme Court, because the Second Circuit said that's stupid, you lose. The Supreme Court in two sentences said, for the reason stated in Kimbrough, the conviction is reversed and remanded back to the district court for sentencing. I went back to the judge. I was all ready to say, who's stupid now? And he was dead. So there's like, you got the last voice in that. But it's a great place to look things. You can see briefs, you can see it. It's there. Somebody else is, it's crowdsourcing. Somebody else is inventing an idea. You can grab it. If 4 people in the Supreme Court think it's a good idea, it's a really good idea for your circuit court. Every circuit court's got a blog. And most of the blogs, there's one written by the federal defenders in almost all the circuits. And I think they're really simple, as in something like the circuit blog is circuit, for instance mine, it's circuit, the number 2, blogspot.com. And you just insert the number of your circuit in there, and you get, most of the federal defenders' offices are writing them, you get a blog on a regular basis. What's going on? What are the decisions, annotations, leads? Every time that you think there's something else that can be added to your case, keep going. Keep a list on your table. Every time you sit there, you just keep writing down ideas. I'm going to send out a letter for this. I'm going to send out a document for this. I'm going to send something out for that. You want to put the government in a position that they are, one is they have their game. They've been preparing for this contest for a year before you even meet your guy. They've interviewed all their witnesses. They've put all their things. They've crowdsourced all their motions. All these 404B motions they filed in the middle of trial, they wrote last year. And so you have to find a way to level that playing field from this to maybe, if you're lucky, like this. The last thing I want to say about this, on this one, is this. I got assigned an organized crime case. And my guy was a hitman for the mob in Brooklyn. Alleged. Well, actually, the jury said he wasn't.
There you go.
And this in the PSR on 100 pages says, well, it doesn't matter, still sentence him to 100 years. But one of the things the judge in that case said, because I came in late, I was Curcio counsel, and then the judge said, now you're the lawyer. I said, that's not the way it works. Curcio counsel is never the lawyer. The judge said, I don't have time for this crap. You're the lawyer. Get it done. I said, get it done? He said, get it done. So I kept asking for more resources. I'd send another letter and say, Judge, I need more money for this. I need more money for this. We had the protective orders. So somebody had to sit with the client in jail every day while he read the stuff. And my client didn't have a great education. His training was in essentially martial arts of sorts, hitman, not in education. So he was a slow reader, but he had to read every document. Your client is a very good source of information on these things. Even for the guy who might smear himself in feces, he could still remember from time to time a detail, a conversation, a place where it occurred, anything. And every time you get that nibble of an anything, it gets a letter to the government saying, I want this document. It gets it, you think of it, every agency that might have thought about that. It's not just the FBI, it's the NSA, it's the DEA, it's ICE, it's local police departments, it's anything. It's the Attorney General's office. You send a letter out to everyone, you send a FOIA request to everyone, you send a subpoena to everyone. Every time they go into a store, you send a subpoena for a videotape record. You say if there's an incident, there's a fight in a store, you send it to the insurance carrier. The point is that it's out there, the government doesn't give it to you. You have to just be such an irritating gnat and go get it. And it is the most important thing that you'll ever do for your case, I think, because your theories have to come from your evidence. The government's not constrained that way, but we are. And if you have that, if you have some nibble, you can make the materiality argument to a judge, which is why they grant the 404Bs, because they say it's not material or it's irrelevant. So, be persistent.
I'm next. I'm up. All right. I represented Tariq Mahana, and just briefly, Tariq did two things. He went to Yemen in 2004 with two other guys, one of whom faked a family illness and left before they got to Yemen, and he became the informant in the case. And another friend who is actually in Syria right now and on the FBI most wanted list. So Tariq went to Yemen ostensibly to look for a terrorist training camp. Our take on this and our defense was that He knew the other two guys wanted to find a terrorist training camp, but what he wanted to find was a school. He was very much a scholar, very much wanting to learn at the foot of sort of masters, which existed all over Yemen. So he went to Yemen. He and his co-defendant, for lack of a better word, schlepped all over Yemen. They had information that somewhere in some part of Yemen, there's some town where there might be some guy who was Egyptian, who fought in the Afghanistan-Soviet war, who used to have a perfume shop 10 years ago, who might think like you do. And they found him. And they find him, and he says, there's nothing here, go home. So Tariq went home. His co-defendant went to Iraq, where he was promptly locked up in an apartment by the insurgents because they thought he was a spy. And Tariq came home, and then the next thing that he did was he devoted himself to, 1, finishing pharmacy school, 2, finding a wife, and 3, writing on the internet, writing on forums, translating, and sort of proliferating information on his own without any contact with Al-Qaeda, but because he thought this was both exciting and important to do. And it was primarily around the war in Iraq, which outraged him. So we got the case, and I happen to like experts, but I also saw the case that there were obvious problems. And I looked at the use of experts in this way. We wanted experts on sort of public perception. What is the history of Islam? The word jihad was not coined by Osama bin Laden. It has a different meaning. Holy warrior does not mean somebody who is going to blow up the World Trade Center. We wanted experts who could be able to explain that. And so we had an expert from the University of Toronto, Mohammed Fadl, who talked at length about this. And what was also important, we thought, was for the jury to understand where our client was coming from. And in terms of humanizing the client, we actually, the opening statement had pictures of him in Little League, in his rock band when he was in high school, his parents, and so forth. But we thought it was important for the jury to understand the history behind sort of the Soviet-Afghanistan war, the idea of Islam being a history of sort of losses over the modern century, the rise of Osama bin Laden, and the kind of where young American Muslim boys were coming from, why they were interested in this, what it meant to them. So that was one set of experts. The next set was an expert explaining our client. Our client was a prolific writer and translator, and 2 of the things that the government really seized on was that he translated something called 39 Ways to Serve and Participate in Jihad, which Evan Coleman described as, one of the most dangerous pieces of, propaganda that ever existed. In fact, it was not a manual. It was a cut and paste, basically, of many aspects of the Quran and various commentaries. So it had things from support the Mujahideen to teach your children to swim. It was a wide range of 39 ways. And what it was really designed for was for someone who was not going anywhere. Tariq realized and knew he was not going anywhere. He was an American citizen. He was not going to renounce his citizenship. And his way to participate in what he felt was an injustice was to do it verbally and to use free speech and to do it through electronics. So we found an expert, Andrew March, in Yale, who had written a great deal about a concept that became very important. And what he did was he explained very graphically to the jury sort of, this is what Al-Qaeda believes in, this is what Tariq Mahana believes in. Here's his writings. This is how you know this is what he believes in. I'm not making this up. We tried to put the entire Quran in as an exhibit. We failed, but we actually did get to play pieces of the Quran being chanted, videotapes, and Andrew March explaining all of this. We had thought about finding and looking for a social scientist, somebody who could talk about media, instant messages, that world where language can be both very harsh and intemperate, but really doesn't mean anything. And we also wanted someone who could talk about young American Muslim males and what was going on. We really were not successful at that. And then the third aspect of an expert was directly attacking pieces of the government's case. So, for example, the issue of Tariq going to Yemen, we had an expert who testified Al-Qaeda was gone in 2004 in Yemen. It's not the Yemen it is today. We had a computer forensics person who testified about sort of much of the way the government's obtaining of electronic evidence or their use of it was unfair. Our case had tremendous number of thumbnail photographs that were on Tarek's computer. So when Tarek went on a website, it would download into the free space in his computer a picture of the World Trade Center, and they showed picture after picture after picture, 42 pictures in a row of the World Trade Center burning. He was 14 at the time. They showed, I think I counted 39 pictures of Osama bin Laden, et cetera, et cetera, et cetera. And we had a computer expert on that. We actually had one very cool expert. We had a linguistics expert who, because I realized as I was watching one of the videos, an hour and a half, I will never get back, that my client had translated that there were some British words in it. Now, I know that because I like English murder mysteries, but the words were on it like Q. We queued up. And I said, wait a minute, this isn't Americanese. So we got a linguistics expert to show that Tarek's translation could not have been the final translation. And that was kind of cool. I like that a lot. And then the fourth type of expert was the issue of refuting Evan Coleman, which is everybody's cross to bear. Motions in limine in Coleman have been filed repeatedly across the country. Judges have restricted his testimony in some regard, but they've never excluded him completely. If you all haven't read the article, A Hedgehog in the Witness Stand, you really should, because that really defines Coleman. And you can see me afterwards for the site. One of the cool things we did is we actually sent a subpoena to Coleman. A subpoena deuce is taken for all his financials as an expert on terrorism, and you would be surprised what that man earns. He has earned over $1 million in the last 3 years on being a terrorism expert. What we did is we told the judge we don't want his personal papers, but if we ask him a question, we want him to be able to look at his tax returns and answer honestly. And the judge bought it, and he had to do it. And he earns a lot of money. We have, by the way, probably all of the Evan Coleman stuff now because we collected from everybody else. So we have his transcripts from law school, from undergraduate school. We have the rejection of his book from an academic press. We have Evan Coleman's stuff. So I'll either put it in Dropbox or just contact us. So our experts to refute Coleman were three, two of whom were excluded. One was the inestimable Mark Sageman, who's probably my favorite expert in the world. Those of you who know him adore him. He, to me, is the person who really is doing the scientific method, the real study on terrorism. He is really the true expert. And what's interesting is this is a guy, a social scientist and a psychiatrist, that when the government wants somebody who's serious, he's the one they go to. And by the government, I mean, you know, the Secret Service on threats to the president, the military on insider threats. He's the person who looks at this stuff. He's the one they go to, not the U.S. attorneys, because for the U.S. attorneys, he looks at their stuff and he says this is nonsense. So Mark Sageman is the sort of anti-Coleman. He basically felt that the world of terrorism is divided into what he calls talkers and doers. The talkers are the social blob. They don't do anything. Our client was part of the social blob. He was not allowed to testify to that because we also had excluded Coleman's testimony that our client fit the terrorist profile. The two experts excluded were Brian Williams, who was going to testify to videos. Evan Coleman likes to say our client translated the video. This was the best recruiting tool Al-Qaeda ever had. It was shown in the training camps across Afghanistan. I'm thinking, how the hell does he know? What, did they watch it by campfire light? I mean, you know, this is a video. Brian Williams was excluded on a less than 1 minute Dauber hearing at sidebar, all right? And we also had a wonderful guy who, if you ever pull together a seminar on experts, he should be on it. His name is Stephen Durloff. He's an economist. And what he was testifying to was the lack of scientific methodology in Coleman's research. And he was furious about this. He felt that it threw all scientific method, all academics. He thought it was a sham, and he was horrified by it. He'd never seen it before, and he was more than willing to testify. Again, he was excluded on a 1 minute, what is he going to say? No, I don't think so. Now, I would also call these Dauber hearings week before Christmas Dauber hearings on a trial that was supposed to last 4 weeks and was now in its 8th week. So that was part of what went on. And the case is on appeal. That issue is part of the brief. On Coleman, one of the things I think that we fought long and hard about in our team was how to cross-examine Coleman. Was it going to be head-on, taking him on in his own area of expertise, which is extremely dangerous, because Coleman to me is like these inveterate liars. You pin him down on something, he makes up something else. I later realized when he had testified that they were watching this video in around campfires in Afghanistan. Where did he get this information? A prosecutor showed it to me. There was a hearing in Guantanamo where a cooperating witness testified that they saw this video in a training camp. Now, how did the cooperating witness, where did that information come from? Did they really see it, or did the government give it to them? So it's this circular sort of reasoning that Coleman, as you all know, he will take information that only fits his theory. And so the issue was, do you hit him head on, or was it around the edges? And the decision was made to go around the edges. So it was around his expertise, his lack of training, his lack of publishing, his lack of travel, his lack of language, the money he was earning, and also a piece of it was to show that he did and was doing exactly what our client was accused of doing. He was translating videos, all right, and he was posting them on the internet. So, was it successful or not? It's hard to say. I mean, I think what Coleman does is he gives the government the one piece that gets them over sort of a Rule 29, which is your client went on a website. The website has somebody who's connected to somebody who's connected to Al-Qaeda. Therefore, your client is supporting material support by either going or writing on this website. And so it seems to me, honestly, that someday somebody could take Coleman down. It's just going to do it, I think you have to have somebody on your team who is devoted to only him and doesn't do anything else in the case, but work on just devastating Evan Coleman. We don't get that kind of money. We don't get those kind of resources, but I think that that's really the only way it's going to happen. Out of curiosity, I started Googling. I wanted to see the first time this issue of videos was mentioned. And what I found was a general in Iraq who was saying, all these kids come on the battlefield, they're 15, 16, they've been watching these videos. He had no information, just kind of made it up. And then it went into congressional hearings, and then Evan Coleman wrote about it, and then it became fact. So the reality is that a lot of this stuff just comes out of these stories people tell without any basis in fact. My last piece is I gave you a list of, early on we identified about 30 experts we thought we could use. And we didn't use all of them. We contacted all of them. Some of them were not interested, mostly the people towards the end, but mostly they were too polite to say so and would simply say, I'm not available. But what we did find was academics were really interested, and we're in Boston, we have a lot of academics, but it was fascinating to me how many academics were truly interested in wanting to work on these kinds of cases, and nobody had asked them. Nobody had ever asked Stephen Durloff if he was interested in this. So I would urge you to, be creative. Start calling universities and colleges. You'd be surprised how many people are willing to come in. And I really believe the more the jury understands about social science and what Yemen is and what this is and what that is, the less foreign it is, the less scary it is. Plus, it was really interesting for us. So, so that's what I would say about experts.
I'm going to talk about the paintball case. It was one of the early ones. And I represented Safuda Chapman. And we were able to get him out on bond pending appeal, which was pretty amazing. And he would sit during the hearings and during the trial, and he had type 1 diabetes, and he would check his blood sugar and pull out his syringe and shoot himself up, and the judge would look at this, and it was not a problem. Nothing was a problem, and he was just a decent, likable guy. And the facts of his case are really outrageous, because it virtually all pre-9/11, and 9/11 changed everything. Had there been no 9/11, there never would have been this case. He was a Marine who got injured when he was like 19 years old. He converted to Islam. He's very Anglo-Protestant kind of guy. Converted to Islam when he was in the Marines in Philippines or wherever, and then he got injured and he lost the ability to produce insulin. So he became a type 1 diabetic. And he got a disability discharge, a 50% disability. He could never be a Marine, and he was dying to be a Marine. He was set the course record in the obstacle course when he was in boot camp. He was a tremendous physical specimen. And then he decided, well, I'll go be a policeman. And so he was a full-time student and worked part-time as a dispatcher in the Northern Virginia Community College for the police department. And he would go to a English-speaking, I won't say it's really a mosque, but it was like a mosque. And he got to meet some people on Friday nights. He would go there with his wife. They'd sit in their separate places. And one day, one of the fellows came up to him and said, listen, we're going to start a paintball thing to get in shape, learn how to shoot, not ride a horse, which was one of the things they're supposed to do as young men, but they would learn the other things, be physically safe so you can defend yourself, defend your religion, defend your country, defend your family. And this is all pre-9/11. Very innocent stuff, and they would go and play paintball because he was a former Marine. He was in charge of discipline and was one of the people in charge all of a sudden. Well, he gets visited by the FBI at work, and they ask him about that. Somebody reported groups of young Muslim men meeting in a parking lot, coming in 10, 12 cars and leaving in 3. What was going on? Everybody in camo. He said, no, we'll go play paintball, tell you where we do it, blah, blah. It's on somebody's uncle's land in Virginia. And they said, okay. And nothing happened. He eventually goes over to Saudi Arabia to teach English, and he gets arrested. He gets arrested because in the interim, when he graduated college, he went to a camp in Pakistan run by Lashkar-e-Taiba, okay, which was not a terrorist organization at the time. And he went to one of the camps, in his mind, for the physical training, running up the mountains, running down the mountains, and that kind of stuff. And in the course of it, he got to shoot an AK-47 at a tree. Now he was a sharpshooter in the Marines. He wanted to find out what this thing was about, and it was a piece of crap, and it wasn't lined up, and he just thought it was a joke, and and that was it. That was 30 years. It was 65 years. Those 3 shots at the tree. And 25 years were for hunting pre-9/11, possession of a firearm during the commission of a crime of violence, a conspiracy to violate the Neutrality Act, because by going to the camp he was lending support for the Pakistani side against India in Kashmir, just some crazy crap. Anyway, he's in the camp at 9/11, hears about 9/11, zooms home to be with his family and his country, because they need to be protected, and runs into all of the discrimination that you would expect and all the harassment you would expect. And that's when he went to Saudi Arabia to teach, and he gets arrested there on an indictment out of the Eastern District called the Paintball Jihad, which the government finally realized was not a good name, even though they're the ones who picked it, and they refused to talk to any of the press if they ever printed that again. And so we refused to talk to the press if they refused to print it again. But we weren't as good a source of information. Anyway, so those are the underlying facts of this case. make a long story short, he wound up getting a 65-year sentence. 10 on the conspiracy and 55 mandatory minimums. The co-conspirator, he came back, that was it, okay? But while he was in transit back between 9/11, the time he got there, El Tamimi and had meetings with Kwan and Royer, El Hamdi, and Masood Khan. The four of them traveled to the same camp. At least 3 of them admitted they went there to train to fight the Americans in Afghanistan, okay? Chapman had nothing to do with that, okay? But he got put in the same indictment with them, in the same count, but different objects. And this becomes important. After he is sentenced, he gets sent by the Bureau of Prisons to the Big Sandy in Tennessee. Now, he's in general population. Not a problem at all. No shots, no write-ups, nothing. Everybody down there liked him. He was an easy guy to get along with. Totally peaceable guy. However, the little gitmo opens up and he gets transferred up to Terre Haute. And has no idea why. There was no hearing, there was nothing, it was just, you're on your way, get your stuff. He gets there, and some of the inmates, including residents or whatever you want to call them, including Royer, file a suit saying, hey, you can't do this. It's a violation of our rights. It's a disciplinary move. It's further away from our families. It's more restrictive. Why are we here? We can't have contact with our family anymore. What's going on? This is a violation of our rights. Chapman joins the suit, and that was a problem for him. Because a few weeks later, his counsel goes up to him as he's praying with Royer, who's the emir of the group, and Chapman and another fellow, and says, you can't pray in groups. You know that. And they didn't immediately break up. They finished their prayers, and then he went up to her and said, what's that all about? You've been letting us do it for a year. You've got it on videotape. Everything's videotaped. You can see we've been doing it for a year. Why now? What's the problem? And she said, don't be sassy. And she writes him up for disobeying an order. And he has his hearing. And they take away 30 days of email privileges and telephones. They don't tell him exactly when it's going to start. So he goes and he attempts to send 2 emails immediately. One, and for doing that, he gets a second strike, okay, for violating. The emails which we have, one was to me, one was to his wife. It says, this is what happened, and very soon I'm going to lose my email privileges, and you won't hear from me. We'll have to correspond by regular mail, and I won't be able to call you. That's all it said. That was a second strike. As a result of that, they transferred him to an SMU in Lewisburg, which is even, not only is it more restrictive, but that's where they send the incorrigible gang leaders, the people you can't leave in population, you have to put them together for the safety of everybody else. That's how, the worst of the worst. And when he gets there, they decide, well, they're going to give him his insulin when they want to give him his insulin, and they start giving it to him 2-3 hours before they feed him. He can't have glucose, he can't have sugar in his cell, so his blood sugar goes down sometimes to 35 or 45, which is really dangerous, and sometimes it goes up to 600. It's just totally out of control. And they refuse to help him at all. And so sometimes he stops taking his insulin in the morning if they come 3 hours before meal, because he doesn't want to go into shock. And then they say, well, he's not following the protocol. And then they take him off insulin completely, and they put him on Metaform, which is for type 2 diabetes. And it's just totally inappropriate. And so we just don't know what the hell to do. So I filed, his habeas was still pending in front of Judge Brinkman. So I filed, and this is in your materials, a habeas corpus a testipacandum, saying I need him brought to court for a hearing that hasn't been scheduled and may never be scheduled, but if you don't do it, he may be dead and therefore unavailable to testify, and here's why. Boom. Okay? And we included in our materials that which we had, which was his copious, detailed account of every day and what was going on with his blood sugars. And my correspondent's trying to get his medical records, saying, Judge, I'd give you the medical records, but I can't get them. Well, she eventually got the government to get them, looked at them. She denied the a testipacandum, but she ordered the government to get him to a hospital. So the government got him moved to Springfield. Okay, now we think we're doing good for him. Okay, he gets to Springfield. Now he's in the SHU. He's completely locked down. 3 guard and a lieutenant to extract him. So if he goes into shock and they can't find the lieutenant, they got to let him die in the cell. And we start corresponding with people at the Bureau of Prisons. What the hell is going on? Why the hell is he? Why is he in the SHU? And they say, well, it's because everybody from an SMU that comes to the hospital is put in the SHU. I said, well, why was he in the SMU? And they say, well, he was bullying people into converting. I said, wouldn't he have to have a hearing? Yes. And I said, can you give me the documents? He said, well, he has them. He had a thing. He had a hearing. I said, I'll check. I checked with him. He said, absolutely no. I'd never heard of this before. So I tell that to the guy I'm dealing with at the Bureau of Prisons, and he sends a thing to the legal department at the Terre Haute and says, can you send me the documentation? And they go, well, we checked, and they're really only those 2 shots, the praying and the emails. So they take him off of the SMU designation, and that means they don't have to have a lieutenant anymore, but they still have 24-hour day lockup and 3 people to extract him. And then they get his diabetes under control, and we're figuring, well, he's going to go back to a CMU someplace, which is a lot better than what he's had on this journey. Now he's in Florence, ADX, under severe restrictions. And why? Because he prayed in a group of 3, and he tried to get the email out to his lawyer and his wife to explain it. And so he's had no physical contact with his family. They're just on these telephones that he drives out to Colorado from Virginia. Same with his children. And, you know, we were able to get him from a CMU all the way to ADX by trying to help him. So what I'm telling you is you got to be careful, because you're dealing with a fascist organization that doesn't care, and the courts won't control. You know, the Johnny Walker Lynn was a huge exception, and good for them. But you know, this is just atrocious. Thank you.
So, comments or questions? Linda?
Yes. Just a couple of comments and then a question for Janice. When you were talking about, Michael, your cases, I agree with you about the community support aspect, because what we know from jurors is if nobody cares about your client, they're not going to care about you. And in debriefing jurors, we hear that a lot. Jurors do look at the audience. They do discuss who the relatives and the friends are, who counsel is talking to. So So I completely agree with you in that regard. I agree and disagree with you about some of these cases with respect to a political context and humanizing your client, because sometimes you've got juries where that will never resonate with them. And so, but what will, if you have a client, and I'm thinking of Dr. Alarian, what will is the principles involved. So in a case like Alarian, where every night the local press was running his old videotapes of him talking about the great Satan, and being a kind of inflammatory and provocative language that we knew the jury was witnessing. We just kept talking about the First Amendment, free speech, and we did well. So I guess what I'm saying is sometimes if you can give that political context, we tried in Holy Land, certainly. I think it's important, but this is so case specific and client specific and community specific. You have to be, in my view, very careful. Which brings me to the Mahana case. In Mahana, I was very interested in, because we use experts in our cases. I'd say probably the premier expert finder in the world is Ms. Hollander over there. But I have a problem with a lot of experts. And I'm wondering, when you picked your jury in Mahana, did you pick your jury thinking that you would be using a lot of experts, so you had a particular kind of juror in mind when you did that?
Well, first of all, our voir dire was so shameful, you have no idea. I mean, the judge told us early on that he was not interested in questionnaires. I submitted a list of about 20 questions. He picked 2. All right. We had next to no information about jurors. We were looking for highly educated jurors. That's the best we could do as sort of a gross sifting point of jurors. And honestly, I mean, in Massachusetts, we don't get lawyer-conducted voir dire. We get next to no questions. We're unfortunately kind of used to picking jurors. And I always sort of jokingly say, I pick anybody who doesn't look like they have a hatchet for a face. I mean, it just, you know, that's the best we could do. Did they have a lot of education? Did they seem like a nice person? Honestly, we had so little information about jurors that was the best we could do. It really was. I mean, I think we had one juror we were very interested in. He was actually in seminary schools. We thought, oh, that's okay. You know, he's going to be interested in the religious aspects of this and the different parts about religion. But we had next to no information about jurors.
But what's your concern about experts? Because you said you had...
Well, because often what happens is we lawyers are interested in experts, but the jurors don't care. I've debriefed lots of jurors who, when asked specifically about what you think about, you know, Levitt or a defense expert, they didn't even pay attention, or they're guns for hire, a pox on both of their houses. So I think that experts are very important, but I think that you have to be judicious and very selective, and then when you pick your jury, you have to orient them in whatever way you can to being receptive to that kind of testimony.
Well, I think you're right. All this is always fact specific. You
Sure.
can't just make generalizations as to what to do and not to. But sometimes an expert coming forth for your client is almost like a character witness. That somebody, like in a Palestinian case, that an Israeli expert would come and testify on behalf of your client, is saying something more than what the expert's actually saying. So in that case, you know, your expert's helping you even beyond their expertise. But it is very fact specific.
Just if I can follow up one thing that he said, which I think is really great, is that your point that not every case uses these things, but if you start your case and apply the facts of your case to the sieve of all the tools, instead of prejudging which tools are not going to work in your community, you apply all the tools to it, every one of the ideas, and then say, now why does this or does this not work? You don't prejudge yourself out of a potential theory. Like you may say that my area, experts are not really going to be productive because of this. But take the time and have people, or have somebody assign themselves just to the idea of an expert, to give you, somebody you trust to give you an opinion, and say, if we did an expert, where is that going to take us? And then what's our best case scenario for that, and then come back.
You also need to know what you expect an expert to say that's going to help your case. So you got to understand what the government's case is first, and where they're coming from. And you know, I think in the paintball case, one of the things that was important was the use of the word jihad. This is one of the early ones. And we went to Esposito, no thank you. We went to some guy at AU, no thank you. You know, and we finally found an imam from Annapolis who was fabulous, and the judge liked him, and he was able to explain. You know, jihad could mean fighting the diabetes. You know, it can be fighting ignorance. It can be whatever it is. It doesn't have to be going and fighting a war. You know, and that was very important. You know. Because nobody knew what the hell jihad meant, you know, other than holy war, which is
scary.
We had Dr. Esposito as an expert in our case. He's helped us a lot in many cases, and I agree with you. All I'm saying is it's so case specific. And we lawyers, I just because I am of two minds about experts. We lawyers tend to be enamored with experts, and because they teach us. And they help us in areas that we don't really know about. But a lot of jury couldn't care less about the testimony. That's what I'm saying.
The one thing about the experts, I think, in some ways, they changed the narrative of our client. So as the case went on, what developed, which we had not expected at all, was that it became the idea that sort of being, you know, pro-Al-Qaeda, you know, wanting to fight, being, you know, very radical, that this was almost a rite of passage from going through sort of adolescence and late adolescence until they came out the other end. Because we had all his friends on the stand all saying, oh, I used to believe that and I don't anymore, and now I'm mature, and now I'm an adult. And the experts kind of ended up supporting that. Now what was interesting is that's probably not who our client was. When he allocated to who he really was, which is why he probably got an additional 2.5 years. But the experts really helped to kind of support that narrative. And in some ways, I think that was important. Of course, we got croaked on secret tape recordings. You know, I mean, that's where these cases are, right? They're not what Evan Coleman says. They're not what this person says. It's what the informant is tape recorded when they're sitting one-on-one with your client in their car. But what are you going to do? You know, you gotta fight the case. You got to defend the case, and you've got to have a theory to bring it forward. So, in part, our theory was our client, you know, had the best of intentions, believed in himself as an American, believed in free speech, and these experts all support what he believed in. And they're Americans, and they're not crazy, and they can talk about, relate jihad to the American Revolution, relate, you know, our client to, you know, I have but one life to give for my country, like that kind of stuff. And making him, normalizing him, I guess is what I would say, or Americanizing his belief with the hope that he wouldn't be this really foreign, horrible person that was going to get on a plane with a box cutter.
Sometimes it's like client testimony without the client being
That's
cross-examined.
right. And that's really what the experts were, because his writings were so prolific, they could really...
They could talk about it,
yeah,
but you don't cross-examine the client and have him fail spectacularly in front of the jury.
Exactly.
Yeah, I just wanted to say two things. One, about experts. My view of experts is that sometimes their best use is to teach you enough so that you can cross-examine the government's expert. And in Holy Land, the government largely won through an expert we could never cross-examine because we didn't ever get to know anything about him. But I'm kind of like Linda. Sometimes I think the jurors just turn off, but I'm a big fan of using experts in all the ways we can think of and then figuring out what the best way is. But what I really wanted to say is something Sam said about resources. And this is just a resource you might not know about. Judge Emmett Sullivan, who was the judge in the Stevens case in Washington, who is the one who told found that the U.S. attorneys had not provided favorable evidence and threw out that case. He has, and he spoke at an NACBL meeting recently and encouraged everyone to go to his website, which I just did, and look at his Brady order. And if you look at his Brady order and just copy it, it's got everything you need for Brady. He also, and it's really a terrific order, and you just go type in Emmett Sullivan Judge, and then when you get on his page, it says go to website, and you go to his website, and there it is, that order. It's got the law, it lays it out, it lays out what he requires and what judges should require. And specifically, he said, I don't ever want to hear any lawyer who's heard this ever talk about exculpatory evidence. It's favorable evidence. Let's talk about what is favorable evidence and don't limit yourself. He also said, and I don't think it's come out yet, because if it has, I can't find it, that he rewrote a section of the federal bench book for judges on Brady, and that it's supposed to have been out in December. He said it would be out, and I haven't seen it.
It's, he said January or
Did he
February.
say January, February?
Yeah.
Okay. So it isn't out yet, but look for it, because the federal bench book that the federal judges use is going to have a whole new section on Brady that is helpful to us.
One of the things along that line is the Ted Stevens case out in Alaska.
That's
Same
the one I'm
case.
talking
Same-
about.
that's the
That's
same
the
case.
one
It
I'm
was
talking
tried in
about.
northern. It was tried in Virginia.
Oh, okay, right.
Right.
Tried in
That's-
Virginia.
he was excellent on that.
Yes, that young lady there.
Oh, it is.
Yes.
Hi, my name is Noreen Shaw. I teach at Columbia Law School at the Human Rights Institute. I work with CART. I've met a bunch of you guys over the last couple of months. I just had a question on John's presentation on post-conviction conditions. Is it the experience of many of you that these kinds of attempts at intervening and trying to get your client into better conditions sometimes backfire? And is the backfiring occurring when you're dealing with BOP, or is it sometimes working with that particular facility, and is it the Terre Haute facilities at the CMUs that then can lead to the spiral? So I guess my question is, where do you locate the most kind of bizarre, arbitrary behavior on the part of the BOP? Is it at the facility level, or is it at the BOP? And how common is it that
I
we're
think,
seeing aggression
if I had to take a
and not
guess,
getting better?
I would think it resides in the FBI. That they're monitoring these prisoners, and they're influencing the Bureau of Prisons about where they should go, kind of classification. They get to read every document that is written by these young men and women. Mail doesn't get delivered in one direction or another until it's been translated and read. And I think they have a tremendous influence, because the Bureau of Prisons personnel in their headquarters were ignorant as to why he went to the SMU. They could not believe it was for what, he only had those 2 shots in 8 years, very minor ones, and yet he wound up in the ADX. So you tell me,
Yeah, I mean, just in relationship to that, I mean, I do think the FBI remains involved from day one, right up through the classification. I'm Bob Boyle, by the way, from New York, and I just dealt with a situation involving Yagi up there from the Boyd case, where he was right from court. His initial classification, he was in Coleman in special housing in what's called administrative segregation, but it's the same thing, for going on 8 months. And during that time, there was a real struggle, in terms of what I was thinking of, do I push them to say, get him out of administrative classification, put him somewhere, because hanging over his head was Florence. So it was because, be careful what you hope for, because, okay, we'll classify him, then comes a letter from P.O. Box 8500 in Florence. And so I didn't really push that hard. And and obviously, family is concerned, because they're like, he can't call, why isn't he classified? But you have to hold up. And it turned out, we only found out just in the past few weeks that Washington disapproved his classification to Florence. And then once we found that out, and they actually told him that after I had written a few letters, then I sent the letter saying, it's been so long, classify him. And I think it was just a few days ago they put him in General Pop in Coleman. Does that mean he won't go to Terre Haute any moment, or one of the lesser, what they consider the lesser? Of course he can. But it's a very tricky situation. And sometimes the client has a better sense of it, and in this situation, than the family, who were very upset. He was like, look, I want to be in population, but they're giving me everything I need. They're not harassing me. So okay, let's just see what's happening. And it's and that may not apply in every case, but it's just and I appreciate you saying you have to just be very careful about how hard you push in that situation, because you don't want to end up in a bad situation.
In my materials, you'll find that we were able to get hold of the documents that indicated why he was being held in the SHU, because it had nothing to do with the SNU, in point of fact. And the reason that they gave is because he's a former Marine who trained with the Taliban to kill American soldiers in Afghanistan. Okay? Where the hell did that come from? You know? It came from his co-defendants, who all testified and were released after 3 to 5 years. They are the ones who did that. He was acquitted of that part of the conspiracy and was never even charged in those overt acts. And so I wrote a letter to the wonderful Gordon Kromberg, who everybody knows and loves, I'm sure. And I showed it to him. I said, Gordon, I'd like to get your help in clearing this up. Would you send a letter to the warden stating that he was never even alleged to have trained with the Taliban and certainly never intended to go fight American soldiers in Afghanistan? And he sends a letter saying it's untrue that he trained with the Taliban. He trained with Lashkar-e-Taiba, another terrorist group, period. That was his response. And so I sent a letter to the warden, copied Gordon, saying, Gordon, thank you so much, but I'm sure, Warden, that if you asked him specifically, he would also tell you that he did not go to, and never intended to go to Afghanistan to fight American soldiers, because he was over there pre-9/11. Okay? Because, he's an ADX. So.
Yeah. In the CMUs, there is a resident FBI agent who is monitoring the CMUs. They're, except for they're not underground, they are functional ADXs. They are monitored 24/7. Their communications have to be in English. They can't have physical contact. Their ability to congregate is limited. They are recorded 24/7, and there's an FBI agent monitoring them full time. To the best of my knowledge, only one Arab has been ever released from the city. Dr. Jayusi, who's my client, who's in the CMU, is in the CMU because Jose Padilla was one of his co-defendants, even though he never met Jose Padilla, never even knew the existence of Jose Padilla. Jose Padilla didn't come around till years after Dr. Jayusi was even out of the picture. But it's entirely political. Placement in the CMU is probably dictated more by DOJ than BOP. And CCR is litigating it right now. Do I sound like DOJ, BOP, CCR?
We know what you mean.
That's right.
Go ahead.
Mike was to the use of experts. I have a counterpart. Linda and I often work together, so I go get all the experts. Like Nancy, I'm a huge believer in experts, regardless of whether they testify. That's the last decision. That's a decision I think you make when you go on. I'm not going to put on a case, but you have to learn. And I put two things. When I started in 2003, I knew very little about the jihad. I knew very little. And the people that she mentioned, Mark Sageman, Brian Williams, others who would run the CIA, taught me for 5 weeks everything, with part. And I think the first thing that you have to do when you get one of these cases, on whatever it is, if you haven't been there, is find out who your guide will be. Who is the person who actually can understand all of this? Whether it's an FBI agent, former, who would teach you, whether it's a professor, whether it's one of these people, because you are going to have to learn. If you don't learn it, you don't know what in their theory is wrong to begin with. And that, to me, that was the absolute critical part of Hamdan and other defenses, was to actually learn about what real terrorists do, so I could distinguish my person from such a person. That, to me, is the first part, is learn terrorism. You got to learn what real terrorists do before you can distinguish your guy.
Anybody else?
I have a question for Sam, which is, our discovery was the government handing us 5 hard drives with about 350,000 documents and saying, here you are. And we could not get the judge to do anything about it. He said that they had more than met their obligations, all right? The irony, of course, is we spent about $600,000 on a computer expert. Yes, we did. Yes, we did. We went in every couple of months for another $100,000. And we'd say to the judge, look, if you want to cut down these costs, have them sort through this and tell us at least a rough cut of what they're going to use and what they're not going to use. But what have you done about that?
So
what have you found successful, if anything?
the only thing I found successful is money.
That's it.
That's
yeah.
it.
Yeah.
So
Yeah.
in the organized
works.
in the organized crime case that I had, we had 130 witnesses and all these other things. So we just kept going back for more money, for more bodies, and we just did we did the general grant approach to it. We were going to throw
Yeah.
bodies at bullets,
Yeah.
and just run out of money, and so we went, something on the order of 10 lawyers for a year, just doing somebody's job was just to listen to tapes and somebody do this other thing. And the thing is, I had a fantastic judge, a guy named Brian Cogan in the Eastern District, who was just fair about it. And then you hear the horror stories of the judges who are absurd about it.
I mean, our judge allowed it.
He allowed it, but that's
Yeah.
not the normal case. I mean,
No.
in the case up in Albany, the judge is like, you can't do anything, you can't have any money.
Very little.
Very little money.
Yeah.
I mean, these things just cost
There are
$1 million.
There are a couple of opinions out there about, burying Brady material in 5 hard drives is like not giving it.
Correct.
But, our judge wasn't responsive to that. I'm just wondering if anybody
Well,
else
there's
has
another thing
any
I thought
other
that was
tactics
useful.
about it.
There's, in the Second Circuit, they probably wanted most of them, there's a budgeting office, and I found that my budgeting guy could be a good advocate for me. That when I didn't make enough progress with the judge, I went to my budgeting guy. So we had a stage 1, stage 2, stage 3 budgets, and so you had to, because it was if it was over capital eligible, then you had these various stage budgets. And he was useful in going to the judge to say, here's what I think we might be able to do. Sometimes they can talk to other budgeting people, and they can get you some material. So we didn't have to buy as much. We had to buy hardware. We had to buy carts to move our stuff around, and hard drives and things of that nature. So he was helpful in getting me those sort of things getting approved. So I think sometimes the budgeting guy in the circuit is very helpful. And often an ex-CJA lawyer, which is what ours was. And so he was very amenable to the conversation.
But I guess, I think that our circuit, in the last 2 weeks, there's a huge issue about spending, and there's going to be a crackdown on this, and maybe that will be an impetus for the government sorting through stuff. But, this just strikes me as absurd.
Oh yeah, I agree completely.
Have you had success?
And also
with
for
that?
continuance.
We had huge down in Raleigh. We won things that no one had ever gotten because of the money. And played this, and I watched them. I was there. The law was completely against me. Forcing them to translate anything, completely against me. Forcing them to transcribe English tapes, completely against me. There's no law for me on this. So I go to the judge and I budget out everything that it's going to cost. And I say, by the way, the government is doing this as well. And they're going to do their version, and I lay out a schedule for when things will happen, when I'll compare my translated version with their translated version of all of them. And the judge realizes he's going to pay for the translation twice. And I'm there. And I said, absolutely. In fact, the case file they're cited says I get an expert to do this, and I would like $673,000, please. And he says, how much? I said, but it's a clear evidence, and Dylan was there, etc. And we go back and forth. He says, well, I think I could get it cheaper. And I said, well, the government says that's how much it'll cost. Blah, 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 blah. They're going to do it twice, by the way, Your Honor. So at the end of it, he goes, The government is hereby ordered in its discovery order to complete its transcripts and turn over every one of them. But we might not use them themselves. I don't care, it's material. Turn them over. You are ordered to do this on this time on a clock period, and it's in contempt if you don't. So they went through and had to translate everything. They had to turn it over chronologically. They had to turn it over in a form that could be used, and they had to report to the court every 2 weeks because there was no way the court was about to spend that kind of money. And I think the money is the way you win this game. You set out and say, here's what it will require to do all of this. And by the way, what I put in the first motion was I want a time, because I set out a potential. I did 2 things in advance. I did what I needed, and then I did a motion for when we would do things. And I said, you know, by the way, Your Honor, we're going to need to get together at this time to compare translations. This point at this point. You know, so I set all of that out. And he realizes, and that educated him.
Right. But you've done your homework.
What's that?
You've done your homework.
Right. I think if you get ahead on the 2 things, suddenly the government's there, and the judge is there. No, you'll do this on this time. He writes out that order. They appealed it. They lost.
For you. Thank you.
Okay, thank you.
I think it's one.
It was funny to watch. It was really funny to watch because I had no basis in the law. None.